Hello and a warm welcome to Well This Week by latestlaws.com. This is a weekly program, so hit the bell icon to get notifications for new videos. My name is Sheetal Joon, Associate Editor, latestlaws.com, and I will be taking you through the significant orders and judgments passed by various courts in the country and some important international news from this week. Let's begin with the Supreme Court this week. Dropping a Google Maps pin cannot be a condition for granting bail, the Supreme Court has observed, indicating it will soon pass a judgment that will end the practice of an accused constantly providing investigators information about their whereabouts. According to a bench of Justice A.S. Oka and Justice Ujjal Bhuyan, a location pin was not only likely to infringe the individual's right to privacy, but could also be misused. The bench said that the various courts, including different benches of the Supreme Court, have been putting the sharing of Google Maps pin as a condition of bail and that it is time for the top court to deliver an authoritative ruling on the issue. During the hearing, the bench emphasized Google India's submission that a pin is innocuous due to the primary function as a tool for navigation and location identification, and that it may not effectively monitor an individual's compliance with the bail terms. The Supreme Court has mandated the enforcement of a minimum one-third women's representation in the Supreme Court Bar Association's positions, including upcoming elections. The bench, consisting of Justice Surya Kant and Justice K.V. Vishwanathan, has mandated that one office bearer position of the SCBA must be exclusively reserved for women in rotation. The Treasurer's position for the 2024-2025 election will be the first under the rotational reservation. The court has mandated that there should be a minimum of one-third representation of women in both the Junior Executive Committee, 3 out of 9 members, and Senior Executive Committee, 2 out of 6 members of the SCBA. A Hindu marriage is not an event for song and dance, wining and dining, or a commercial transaction, the Supreme Court has observed, as it said that it cannot be recognized in the absence of a valid ceremony under the Hindu Marriage Act. A bench of Justice B.V. Nagaratna and Justice Augustine George Massey said that a Hindu marriage is a samskara and sacrament which has to be accorded its status as an institution of great value in Indian society. The Kolkata High Court order directing the SCBA to probe into the role of West Bengal government officials in an alleged teacher recruitment scam was stayed by the Supreme Court in a huge relief to the Mamata Banerjee-led government. The top court was hearing a petition by the state government against a High Court order invalidating the appointment of 25,753 teachers and non-teaching staff made by the School Service Commissions (SSC) in state-run and state-aided schools. Now let's have an overview of High Courts. In a major ruling, the Delhi High Court has ruled that the properties attached under the PMLA cannot legally be treated as proceeds of crime or be viewed as a property derived or obtained from the criminal activity once the accused is acquitted in the predicated or scheduled offence. A single judge bench of Justice Vikas Mahajan observed that scheduled offence and the proceeds of crime generated therefrom is the very foundation of the offence of money laundering. Once a person is discharged or acquitted from the scheduled offence, the very foundation gets knocked out and the charge of money laundering will not survive, as there will be no proceeds of crime. The court also stressed that if an accused under the PMLA is discharged or acquitted, the special judge under Section 8(6) has no option but to pass an order releasing the properties attached under the PMLA. The single judge bench of the Tripura High Court has held that the wife, being well qualified, having a postgraduate degree, working as a lecturer and earning something, is not a ground to reject her claim for maintenance, as it directed the husband to pay wife the maintenance who is serving in the education department. It was furthermore observed that the respondent wife has been able to prove that she has been neglected and refused to provide maintenance by her husband. The Kolkata High Court, while rejecting an application filed by the petitioner assailing the bail granted to the opposite party on the grounds that the court failed to take into consideration the restrictions under Section 2126 of the Companies Act, held that the restrictions to bail in the special statute like the present one may not be applied in those cases where the accused had cooperated during the investigation and had not been consciously arrested. The court noted that Section 2126 of the Companies Act mandates that the court to give an opportunity of hearing to the public prosecutor, and in the event the public prosecutor opposes the bail, the court has to record its satisfaction that the accused is not guilty of the offence and is not likely to commit a similar offence in future before releasing the accused on bail. The Andra Pradesh High Court has observed that the co-accused released on bail cannot be a ground to grant anticipatory bail. The single judge bench of the Andhra Pradesh High Court has held that each case is evaluated based on its own merits, and the fact that others were released on bail does not automatically entitle the petitioner to anticipatory bail. It was furthermore observed that the anticipatory bail, the extraordinary privilege, should be granted only in exceptional circumstances where the court is prima facie convinced that the petitioner is enwrapped in the crime and unlikely to misuse the liberty granted. The single judge bench of the Jharkhand High Court has held that if the complainant did not express any intention to produce any evidence in the support of the prosecution after giving a reasonable opportunity, the magistrate concerned has every right to close the before charge evidence, and once such express order closing the before charge evidence is passed by the magistrate, the stage under section 244(1) of the Code of Criminal Procedure comes to an end whether or not the evidence as envisaged under section 244 of the Code of Criminal Procedure is produced by the complainant or not. Moving on to international news this week. The former US president was punished this week by the New York judge overseeing his hush money trial for disobeying a gag order, and the judge threatened to put him in jail if he broke the order again. The 77-year-old Trump running campaign for the third time was found contempt of court by Judge Juan Merkin for disobeying a directive not to disparage witnesses, jurors, court employees, or other families in public. The judge delivered his order before testimony resumed in Trump's historic trial on charges of falsifying business records to pay hush money to an adult movie star. In a fresh development in the Cypher case, the Islamabad High Court has observed that the Federal Investigation Agency (FIA) has nothing to prove that the jailed ex-Prime Minister Imran Khan retained the confidential diplomatic cable and it went missing from his custody. In the Cypher case, Pakistan Tehreek-e-Insaf (PTI) founder and former Prime Minister of Pakistan was sentenced to 10 years of imprisonment along with ex-Foreign Minister Shah Mahmood Qureshi. Pop icon Britney Spears and her father Jamie Spears will no longer be pursuing the legal battle over the conservatorship. The two have settled the dispute over legal fees after the first filing in December 2021. More than 2 years after the conservatorship that had given the singer's father control over her life ended, the Spears settled the dispute over the legal fees pertaining to the conservatorship battle. In the end, we have miscellaneous news. A court in Delhi has reprimanded the Enforcement Directorate for recording statements of private doctors under the Prevention of Money Laundering Act. The Enforcement Directorate is bound by the rule of law and cannot act mighty against citizens who are not even a suspect, said Special Judge Vishal Gogne. The court, while admonishing the Federal Probe Agency, observed that provisions under Section 50 cannot be used for purposes unrelated to the collection of evidence or proceeding regarding the proceeds of crime and the ED. Pharmaceutical giant AstraZeneca has accepted for the first time that its COVID vaccine can, in very rare cases, cause TTS. The admission was made in a legal document submitted to the UK High Court in February. The company stated in the document that TTS can happen even if there is no vaccination, adding that expert testimony will be required to determine causation in every individual case. AstraZeneca has been fighting a class action lawsuit that alleges its COVID vaccine, which was developed with the help of University of Oxford, has led to several deaths and serious injury. According to the attorneys, some households faced a devastating effect of the vaccination. Thank you for watching and have a nice day. This is a weekly program, and to get more information, please check the description box, and for weekly updates, like and subscribe to our channel.